Hey, all, it's Shawn McBride. I'm a practicing business lawyer, corporate lawyer, and I've reviewed the recent Elon Musk compensation case, all 201 pages, so that you don't have to. 939 footnotes in there, by the way. I did not read every footnote. Most of the footnotes were just citing other material, but very extensive opinion, 201 pages, as I mentioned. Very long. Some people are completely surprised by the outcome. I've got to say, I am not completely shocked. Some of the analysis is interesting, how the court got where it got to. We're going to walk you through all of that, how we got there, and why they came down the way they did. But we'll also take a look at what Elon is talking about right now, which is should he reincorporate in Texas? I'm in a unique position. I'm licensed in a number of states. You can check all that out at rsmlawpllc.com, but including those is Delaware and Texas. And I've practiced law in both states, so I'm intimately familiar with the two different states and their legal systems. So we'll get into whether it makes sense to move from Delaware to Texas to avoid this type of thing happening in the future, where things are going. And then I'm also going to give some tips on how to apply this to smaller businesses, right? There's obviously only one Tesla out there. Elon Musk, being the richest man in the world, has a completely different compensation package than you or I or the companies we might work with, the companies we might lead, the boards we might be on, our family businesses. But there are definitely lessons from what we see in the Elon Musk case that we can bring back to our particular companies and family businesses and the companies that we're building to make sure that we don't end up in similar situations. We'll start by talking about the fact that U.S. law typically uses what we call the internal affairs doctrine for businesses. And what this means simply is that your internal affairs are generally governed by the state in which you are incorporated. So you get to pick and choose whose system you want to work under, right? And Tesla, like many Fortune 500 companies, has picked Delaware as their state of incorporation and thereby the state that governs their internal affairs. Elon is talking about moving the company from Delaware to Texas, which would change this internal affairs governance. And this is something we see. It may not be super common as a percentage of all businesses, but I do have businesses that I work with that have moved from one state to another that have reincorporated. Sometimes you do that for investors. Often investors are very interested in you being a Delaware entity, a Delaware corporation or a Delaware LLC before they want to invest because of uniformity. They understand Delaware law. There's other reasons they might choose Delaware. We'll probably talk about a little bit of that later today. So we have that ability to pick and choose, but then you can move your business too. And a lot of people with small businesses, either correctly or incorrectly, will move their business from one state to another if they physically move. Let's say you live in New York and you move to Florida, you may want to move your New York entities to Florida. That may or may not be necessary. That is beyond the scope. I know we do have a video on that here on the YouTube channel where we talk about state of incorporation. And if you talk about particular questions and issues that pop up here that are tangential in the comments, I may pick those up in future videos. So feel free to comment with your questions and requests. And if I see a critical mass or an interesting topic, I may pick it over. But let's jump into this. What we ended up with is the Delaware court rescinded Elon Musk's pay package. So essentially they said, we're taking away his pay. Now, the people that were arguing for Elon Musk, because what happens, of course, in a court case, you have two different sides. And one side's pushing one thing, one side's pushing the other. Well, Elon's lawyers, the defendants in this case, were saying, hey, it would be completely unfair to leave Elon with a rescinded pay package because that means he doesn't get paid for his time. But the court looked at his equity ownership, the fact he has over 20% of Tesla, and said, well, you're getting money because you own that 20%. Well, he got nothing extra for the time and effort he put into being CEO, which was significant. But he did get his general increase in value by making the company better, the rising ship. He got 20+% of the value from that. So it is a bit of a shocking outcome. They completely tore this thing apart. But for me, as I read the opinion and the facts and the details, I am not shocked why we got to where we got to. So let's jump into this. And Delaware, as the court notes at one point in the opinion, has three levels of review for transactions. We have what we call the business judgment rule. That's often viewed as the default. If there's nothing unusual going on, we're going to do what we call a business judgment review. And if the board or the decision maker uses business judgment, they collect the facts and they make a decision, the courts don't want to go in and re-review it. We also have what we call the enhanced scrutiny level of review in the middle. And then we have the entire fairness. Entire fairness becomes very relevant to this case for reasons we'll talk about as we jump into it. So if you go to the Delaware General Corporation Law, it's a long corporate statute that has been created in Delaware and revised, and it states how essentially you run a business. And it presents a lot of different scenarios. Setting up the company, creating your board of directors, shareholder votes, all the things that you would expect in how you run a company. A lot of that is baked into the written law. So this is great because for lawyers, you can go refer to this. Now, of course, you also need to look at case law in addition, because the cases really tell you what that wording means. But Delaware has a very comprehensive statute. It walks through the process. It tells you what's what and what's meaningful. So we know what we need to do in an interested director transaction. And so if we go to DGCL section 144, it essentially tells us if we have an interested director transaction, we need to get approval of it through the disinterested parties, people who are not interested in the outcome, people who are not beholden to a certain outcome. And if we can't do that, we can get a shareholder vote. Another option under DGCL 144 is that to show that the transaction is entirely fair. So as the court's working through that, they're grappling with how to balance this. Was this fair? Did it work correctly? And I'm going to take a second here on my end. I'm not going to put it up on the screen today, but I'm going to pull up DGCL 144 so I can quote a little bit of it for you. So it talks about a transaction between a corporation and its directors, and it is not going to be avoidable solely because a director is interested, director or officer is interested in the transaction. If there is disclosure to the board or a committee, and the board or committee approves the transaction through disinterested directors. That is one way you get an interested director transaction approved under DGCL 144. And of course, backing up, we know that Elon was interested in this transaction because he was the CEO. He owned 21% of the shares. He had relationships with a lot of board members, which we'll be talking about later in this video. Or, there's an or here, another way to get approved is to disclose the material facts and go to the stockholders and get the stockholders to approve the transaction. So that's number two. That's a second hoop you can jump through. The third hoop, and again, an or, one of the three, don't have to be all three, just one of the three, has to be fair to the corporation as a whole. So 1, 2, or 3, we get there and we get the transaction approved. Now, at some point in this 201-page opinion, the board spends a lot of time talking about Elon and being a superstar CEO and how he really is this unusual CEO, and therefore he may need to be treated differently, and it may cause the board to treat him differently, and that becomes important to their decision making. So we'll probably come back to that in a little bit, but let's jump into what really happened and what really caused this decision to go astray. So Elon's lawyers, of course, appear to have wanted him to go through all three different hoops here, right? So they wanted him to both get a disinterested director vote, which they attempted to do. They wanted him to get shareholder approval. And then, of course, there is some work on trying to make this transaction look entirely fair. So this is a common strategy in business and business law, is to try to protect yourself multiple ways. If there are alternatives in a statute, a lot of good lawyers will want you to try to hit it three different ways so that if one fails, you've got the other to fall back on. Unfortunately, here, the court didn't like any of the three in these facts. So let's take a look at what was happening here and why the court didn't really like it. Well, the first hoop we talk about is having a vote of disinterested directors. And the court is really, really suspicious about this board and the compensation committee. So Tesla is set up such that it has a compensation committee that is a group of the members of the board of directors who meet and work on compensation issues. But they also have the larger board of directors, the leaders of the business that have the voting power given by the stockholders. The compensation committee did a lot of work, but ultimately there are votes at the board level. Well, the court goes into a lot of detail about the board members and their relationships with Elon Musk. And so this becomes problematic. Again, in order to have a proper approval under 144 of the DGCL, you need disinterested directors. And the court was not impressed with the level of disinterestedness potentially of these board directors. A lot of them had personal relationships. They were traveling, going on vacation with Elon, owned parts of his other companies. There were a lot of interconnectedness. Additionally, a lot of facts in the case point to Elon controlling the timeline. He's telling them when to meet. He's speeding things up. He's slowing things down. Elon's also setting the terms of the negotiations. So what the court was really pointing to, looking for here, in my opinion, is they wanted to show an independence. They wanted a committee or a board that was against Elon. They wanted a negotiation, more of a classic back and forth, right? We can do this deal. We cannot do this deal. We can walk away. We cannot walk away. They did not think that that was present here because Elon had so much power and he was so connected to so many members of the committee or the board. I also didn't like the fact that there were not good records for decision making. So one of the things you'll typically do in a corporate business situation is keep records of what's happening, right? You want to justify why you made the decision and you want to talk about the facts that the board deliberated, what they considered. Now, minutes are summary, right? They are not a transcript of a board meeting, but they summarize what's happening. And in a lot of cases here, when there were meetings or major decisions made, there was no factual record. So the court really did not like the record keeping here and the extent of the details on why the decisions were made. So there are some cases where there were decisions made, but there were not minutes or contemporaneous at the same time records about why. And so courts really like contemporaneous records. They like records that are made at about the same time things happen. They don't want people to go back and change history. So it's very important when you're thinking about your business is to get contemporaneous records. It appears that there was some lacking contemporaneous records here. The people were not keeping track of what was happening and why at the time it was happening. Of course, everybody's going to go back and view things with a different set of eyes after the fact. Additionally, there was a lack of benchmarking. The court looks at the fact that this compensation committee and ultimately the board didn't really go look at what other CEO packages were. And part of the board and compensation committee's argument was, hey, we can't really do that. This is Elon Musk. He's a very unique guy. We can't go out and look at other CEOs and match them up to Elon Musk. And there's some truth to that. But the court really wanted them to try and to apply by analogy. And also, the court did not like the fact that there was a lack of conflict. One of the board members testified that there was not a feeling of different sides in the negotiations. It felt like they were all working together. Now, this is very, very tricky as a company. You've got a CEO, and presumably everybody likes Elon because he is doing amazing things and building Tesla and taking it through an impossible journey of growth. But the court wants this compensation committee and these independent directors to stop all that, to stop liking each other, to stop being part of the team, and to negotiate against him. So This is not surprising that they didn't like this, but it raises a really practical question, which is when you're doing these negotiations as a business, or if you're a lawyer like myself advising other businesses, how do you make these things look adversarial without damaging the relationships? That is a really hard box that this court is trying to put them in that is really, really challenging. By the way, I see some of you viewing live. If you're viewing live here and you have questions, go ahead and drop them. If you're catching this recorded, also feel free to put comments and questions in. I will try to go back and get those recordings. You can also look at our Substack where I'll do a write-up on this and include the video. You can put comments there as well. So the court does not like this lack of negotiating power. They also don't like how Musk is running his combined entities. There's a lot of talk about SpaceX and Boring Company and these other businesses he has, his acquisition of Twitter, how he's coming and going from being part of Tesla. And in fact, at one point, they used a bunch of Tesla engineers to go look at things at Twitter. And she's really, really not happy with how Elon is coming and going from the company and is maybe using it more personally, right? And that's not really directly on point about this decision-making process and whether it was approved correctly. But you can see how some of these ancillary facts get into the court's mind about whether they like people or not. So because of this lack of independence, because people are not negotiating properly, because there's not the adversarial relationship, because there's not the fighting, because Elon Musk is setting the timelines, he's speeding up his compensation package negotiations, he's slowing it down, he's saying when the meeting should happen, and because he was setting kind of the key terms and what the brackets of what we're talking about, what we're not talking about in the compensation package. Court is not wild about what the board did and says this was not a disinterested transaction. Everybody knew each other too well. Invalid approval. That is not a surprising outcome, indeed, because he does have a large percentage of the company. He does have relationships with a lot of board members. So not surprising. Although it does raise the question, of course, in every board, there is going to be some degree of personal relationship between the officers and the directors. You know, they are going to occasionally go on trips together. They are going to go to meetings together. They are going to do things together. The court does not like it. So not surprised by that outcome. What a lot of people, and I've seen in the comments on social media, are shocked about is the fact that there was indeed an independent stockholder approval of this thing, right? So how do we get from having an independent stockholder approval to getting a pay package rescinded? We'll jump into that, but let's talk about kind of some of the things here that are going on in the negotiation the court spends a lot of time on that are critical to the stockholder vote. So there were very large goals here, but the court looks at the goals and the metrics of this compensation package for Elon Musk and says, these aren't really stretch goals. They're not big goals. They're goals, but they're not things that we really, really are stretching for. So if we're stretching, we need a bigger targets. And so they're not happy with how the board and committee set the targets. They also don't like the fact that the board didn't spend a lot of time deliberating over whether Elon Musk needed more compensation. The arguments made at several places in the court case or several places in the opinion, the judge states, you know, it doesn't appear that Elon Musk would have stopped working as the CEO even if he didn't get a pay package. So there wasn't the adversarial relationship, but there wasn't even a discussion of what would Elon do if he didn't get the pay package, right? He was going to probably be the CEO of Tesla, even without an amazing pay package. And the court puts a lot of weight on that. Additionally, in this package that comes together, it doesn't require Elon Musk to stay in the company as the CEO, right? So the court's not happy with the fact that there's one of the excuses or one of the reasons that is made for Elon's Musk pay package is that they want him to stay in the company, but they didn't actually get it into the contract that he had to stay as CEO to get the compensation package. The court's also not wild about the timeline of this thing. It is started on a rush. There's going to be a meeting. They started spring. There's going to be a meeting in July, and the delay, speed up, slow down, largely at the whims of Elon Musk. And then the pay package is approved in January. So a long timeline. It took almost a year to negotiate this package from April to January. But the stops and starts are dictated by Elon Musk. So they don't feel like that whole time was used constructively. And there's discussion in there about it's not the amount of time, it's the effective use of time. The court talks about it. There's a bias towards Musk's timeline. Musk is adjusting the timeline. Also, while the board is talking about this compensation package and talking about what Elon Musk should be paid and not paid, again, another lack in this record keeping is there's no notes about the board negotiating for the minority stockholders. So nobody stopped and said, hey, we've got to do what's right for the little guys, right? We're looking out for them. So they didn't really keep their notes that we're not just looking out for Tesla, we're not looking out for Elon, we're looking out for the little guy. The court appears to have wanted statements in the minutes, in the notes, saying we are looking out for the minority stockholders. And again, as we're going to bring this into lessons for smaller businesses later, one of the things we know now is let's put notes in there about the minority stockholders. Best interest of all stockholders. We're doing it for the little guy, not just for Elon. Also did not like the size of Elon's ownership percentage and his total compensation package. Obviously, $55.8 billion is the number cited in there. That is a huge number, particularly for a judge sitting on a court. So that these numbers look astronomical. And the court didn't like the size of that, and then looked at what he would have got if he was a private equity investor. A lot of times private equity companies take a 20% carried interest, which is essentially 20% of the profits to the private equity company. And they're like, you're getting even more than that, Elon, because you own 21.8% of the company. Now, one issue or exception I take where they keep referring to Elon's 21.8% ownership of the company and how he's getting compensated through that is he's got capital involved in that, right? He could liquidate that 21.8% interest and put it into another company and get compensated for it, or could just even put it in a savings account, right? And he would get interest on it. He's not getting compensated for that. So he's not really getting both compensation for his capital investment plus his work efforts. They really merged the two together in their analysis. But again, this is the judge, maybe an issue for appeal. We'll probably talk about appeal later, but the judge has a lot of power in these equitable cases, and that's what this is. This ends up in Delaware's Chancery Court, which is a court of equity, which is essentially supposed to do what's fair or what's right. So the court looks at the company's attempts to insulate this through a shareholder vote. So as we talked about, 3 different buckets here we can approve on. We can get it approved by the board. We failed on that bucket, as we discussed here. We can get it approved by the shareholders, or we have entire fairness still coming up. And so let's look at this shareholder vote. Well, the company attempted to go out and get shareholders to vote for this. Now, one thing I've done for you here is, again, it's a 201-page opinion. As we're talking about this, I've collected all the different facts and discussions and organized them by category. If you go read the 201-page opinion, you'll see these things scattered at different points. It's not all directly in clear sections. So I'm kind of organizing things for you. You'll have to read the whole 201 pages and collect different pieces to get where we're going. But I collected a lot of different sections in there about shareholder votes, bring them all together for you now to talk about what the issues were. So one thing they didn't like was with this independent stockholder vote through the proxy statement to get this transaction approved, to get the compensation package okayed. There was some pre-work before this thing even went out for vote. Elon and his insiders were contacting some major stockholders trying to get approval. So they didn't like that. This is pretty common in this practice. People do go out and talk to stockholders, get votes prepackaged. But again, when you get into these heavy-duty litigations, every fact can go for or against you. Here they put a fact against them by going out and contacting stockholders in advance. They also make a statement in the proxy that this was approved by independent directors. So the whole point of the shareholder vote is to insulate the decision. But when they're going to get the insulation from the decision, they're saying it's approved by independent directors. And again, the court did not like the independents. So what they've done now is they've compounded the problem. And this is a good lesson when you're getting approvals of these types of transactions. Do your disinterested director vote. And then again, if you're going to be the good lawyer or the good business and get those second and third layers of approvals, well, don't interconnect them this way, right? They interconnected it by saying, hey, we got this approval over here. It was independent directors. So they're telling the stockholders that there was this outside independent review. Court doesn't like that. So you might be better off to just say, hey, we're asking for your approval and not go as heavily into the independence of the board, because they appear to believe that those stockholders relied on the independence to get here. And because of that, they feel like maybe the stockholders wouldn't, right? That an independent group of directors approved this, that it was okay. So don't make those kind of claims about the independence unless you can really, really back them up. And they talk about the fact that these compensation committee connections to Musk were not disclosed. Many of them were getting a material part of their wealth from Tesla. They were traveling with Elon. They were owning other Elon companies. And they said, how can you call these people independent when there's all these interconnections? It really does beg the question, how much disclosure is needed? Elon Musk has multiple companies. Everybody knows that. Elon Musk, of course, has a lot of investments. Of course, people are on the board are getting compensated. It really becomes a question now from a disclosure standpoint is how deep down this rabbit hole do you get? But the court is not happy that the independence of the directors is claimed in obtaining the stockholder votes. They also didn't like the lack of disclosure of the process. So this proxy talks about the fact that there was a independent director vote, that it's approved, but the compensation committee and the independent directors voting and the speeding up and the slowing down and the outside review and the benchmarking and all of this stuff is not disclosed to the stockholders in a way the court likes. So they feel like the courts didn't get, the court feels the stockholders didn't get enough disclosure on the process, including the fact that Elon Musk was setting many of the material terms, right? So they feel like the stockholders needed to know that Elon Musk was driving this timeline, had set the framework. So, again, how much detail you give, the court wanted a lot more detail in the proxy. Also, one thing that comes up a couple times in this case, early on and again referenced later, is there were internal projections about how Tesla was going to do. There were these equity-based awards and compensation package. And the internal projections were such that it was likely that Tesla was going to have to pay the whole or a large part of the compensation package. And so at one point, they claim that, these are stretch goals, that the company is going to, that Elon's going to be incentivized to try to get there. It's going to be good for the company. But they have internal meeting notes saying that, they're likely to get there, and they have projections showing they're likely to get there. Meanwhile, also on the side, they do a 10Q, which says they're likely to have to pay at least some of this compensation. So the court feels like there was a misleading of the stockholders here. And that disclosure after the fact, shortly after the fact, really called into question what was disclosed. They also said you need more than just economic disclosures. The defendants, the people trying to defend Elon Musk in this case, say, hey, we told you about the economics. We told you what was going on here. What's the surprise? Because all you got to do is look at this. And the court says, and we need to know more. We need to know what's going on in order to get this properly approved. We need all this interested director stuff disclosed. We need to know the details of the process. We need to know what's happening. You can't just short circuit that. And then also there was pressure put on some dissenting stockholders in the voting process, where Musk either wanted them to sell this company and other companies or wanted them excluded from future meetings, etc. So the court does not like the fact that there's pressure put on people with respect to being dissenting stockholders. So all of this tallies up to the fact that the court said, hey, the stockholders didn't have all the information. So because there was a lack of disclosure, because there was a lack of details, because the process wasn't disclosed, because of all these defects we've kind of walked through, this is not good or fair, and you didn't get a proper vote. So we're just going to throw the vote out because you didn't give them the information. And again, if you go back to DGCL 144, as we talked about earlier, in order to get a disinterested vote and to get the stockholders to approve it, the material facts as the directors or officers' relationship or interest as to contract or transaction has to be disclosed or be known to the stockholders and has to be specifically improved in good faith by the stockholders. So they're tearing this section apart and saying, no, 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 no. You did not get the stockholder approval because you didn't get the good faith. You didn't meet the burden of telling them all the information. So throw it out. And the third prong left, again, two prongs. We had the director vote. We failed on that for the reasons we discussed here, or at least the court concluded failed on that. Failed on the stockholder vote, according to the court, because of the reasons we just discussed. And the third way you can do this is have a transaction that is entirely fair, right? So at the end of the day, that's the last hope that's left. And the court really set the facts that they didn't think this was entirely fair. We had that lack of deliberation. We had MUSK in control, MUSK setting the timelines, MUSK adjusting the terms throughout the transaction, lack of notes about protecting the minority stockholders. So a lot of stuff here. The court says, hey, this does not look fair, and we didn't do the process to justify it, right? So usually if you're going to try to justify something on entire fairness, you want a good record of why it's fair. Third party opinions, you want statements, you want good materials that show, hey, this is fair. Not really present here in the record, at least according to the court. So where do we go here in Delaware? We've got a rescission now. So they've pulled this pay package out. Elon's back to just getting his compensation as a 21% owner through the appreciation of his stock, no separate compensation as a CEO. Obviously, this thing is set up for potential appeal, and I think there is a good likelihood that Elon's people will come in and try to fight this. But the court has really set a long 201-page record of things they don't like here. And it really is going to be hard to go back and show some of the entire fairness. There is these issues with the shareholder vote. Maybe a higher court disagrees, but likely it's going to be upheld. Now, one thing you've heard Elon Musk talk about here is, should I reincorporate in Texas? And that certainly is an option. This happens, as we discussed at the opening of the business. You can reincorporate your business and move it from one state to another. Certainly in this case, that will bring up an interesting analysis. Can you relocate the business in order to get different internal affairs? Could there be a lawsuit about the relocation of the business? I leave that open. I haven't seen those types of lawsuits, but I think that theoretically may be possible. The question is, would Texas be better? And here's the issue here, is you end up in Texas Business Organization Code section 21.418. And I'm going to pull that up here on the other screen so I can walk you through it. But it's going to end up looking a lot like the same section he had problems with in DGCL. So the Texas Business Organizations Code, which covers all types of business entities in Texas, but then goes into subsections on different types of entities. 21.418 is one of the ones that is corporation focused in Texas, and it applies to transactions between a corporation and officer or director when there is these kind of conflicts. And so in order to get approval, you need to have full disclosure of the material facts and the relationship to be disclosed or known. So very similar language to Delaware, and either goes to a board or committee, and the board or committee approves it through the disinterested directors. Again, very similar to Delaware. Or it goes to a shareholders vote, and the shareholders approve it in good faith. Alternative here, so Delaware structures it a little bit differently. Texas says two ways to get an approval and gives you two different approvals, or you are entirely fair. Delaware lists as three different things. Essentially, these are basically the same standard on this transaction. So there is no saying we would have got a different outcome in Texas, right? It is in fact very likely that we would have got the same outcome had Tesla been a Texas corporation versus a Delaware corporation. We would have been going through these same prongs. Was there a proper disinterested director vote? Was there a proper shareholder vote? Was there entire fairness? We're going to end up in the exact same type of analysis. Now, some of the downsides of Texas, and again, I'm licensed in both states. I've worked with businesses in both states. I deal with both states regularly still. And Delaware gets updated annually. And I would not be surprised if Tesla stays in Delaware and works through the back channels with the Delaware lawyers. They could get some clarifications or updates to the law that would protect them going forward. Usually those updates are done every spring. They usually become law in the summer. So we could be looking at the summer of this year. We could potentially have the Delaware law edited. Texas, the legislature does not meet very frequently. They rarely address the corporate statute. They're busy on other things. And this is partially the economics. Delaware is a small state. Texas is a huge state. Delaware, they make a lot of money off these corporate filings and things. Texas, it's a smaller percentage of state revenue. So Delaware is more motivated to keep their laws updated and to keep everybody coming back and paying their franchise tax fees and other fees to being a Delaware entity. So would we get a different result in Texas? Probably not. And Elon's going to have a harder time updating and changing Delaware law, updating, changing Texas law to match what he needs versus Delaware law. He might actually be able to get edits in Delaware. Also, Delaware has a dedicated business court, and they have had that for many, many years. The Court of Chancery, it's well respected. This 201-page opinion, you may agree with it, you may disagree with it. That's all good, but it shows a lot of reasoning, analysis, and understanding of the law. In Texas, you end up right now in a general trial court. So you will be mixed in with other cases that are not nearly as business oriented. And you'll have a judge that is doing both business cases and non-business cases. So you may not get the same level of sophistication. You might luck into it, but you might not. Now, Texas does have business courts coming effective September 1, 2024 under a new statute. So that will start becoming available here in less than a year. However, it's going to be a brand new court system that is going to be developed. So it's going to take some time for it to get its feet under it and to develop. So what is our lesson here for smaller businesses, right? Most of you are not running a Tesla or a SpaceX to the extent you're involved in a business. Maybe you're dealing with a family business, maybe a private business you own. Maybe some of the higher levels are sitting on the boards of some other companies, et cetera. So I want to address some learning basically for the rest of us that aren't at Tesla or aren't running a major public company who certainly got a lot of lessons from this case. These same types of issues can come up in smaller businesses. You or I could have these come up. A lot of times we see these come up with respect to a divorce. Somebody gets divorced and they're not happy and they want to go back and reinvestigate the corporate history, right? The ex-spouse now says, hey, let's go back and look at whether things are being run fairly. Maybe you have a situation where ownership interest in the company got split in a divorce and one spouse is still running the business. Well, the ex-spouse can come calling later and saying, I don't like the way things are running. We also see this with families. Somebody, father and mother that owns the business dies, kids get the business. Now they suddenly don't like each other. We also see it with minority stockholders. We sometimes have somebody who maybe was important in the founding of the company, and now they're an adversary to the company, right? All these different combinations of things can happen. And so it's important that we understand these lessons for our smaller businesses. Same corporate statutes can apply. If you're a Delaware corporation or you're a Texas corporation, you're going to be under those same two statutes that we talked about today. You're going to be under DGCL 144. You're going to be under TBOC 21.418. You're going to be covered by these same laws. The same principles are going to apply. You need the same approvals for interested transactions. Now, your analysis might be a lot less complex. You may not have as many interconnections. Obviously, the number of zeros involved are going to be lower. But the lessons from here, as far as how to document, how to disclose, how to write things up, all apply. And even though this is a Delaware corporation, and Elon's talking about being a Texas corporation, I think a lot of people from other states can take lessons from this as well. Obviously, talk to your lawyer, talk about your facts, talk about specific rulings in your state that may contravene this. But a lot of these corporate statutes look alike. You can see how similar the Delaware statute is to the Texas statute, right? And because of that, we know that we might reach the same result, and we might reach another result in another state. They're all most of the states I'm familiar with have a very similar process on interested transactions as far as getting the approvals. There may be minor details in the wording, there may be case differences, there may be presumptions that are different, but long story short, this same analysis applies for all of us. So I hope that's helpful, folks. Looking forward to viewing your comments. Tell me what you think about the Elon case, whether you think this was correct, what you would do differently. And if you have ideas for videos, go ahead and drop them in there. Just don't put anything confidential. Obviously, when you comment publicly on one of these social media profiles, other people would see it. So don't put things that are very specific about your business or your details. Just put general questions. And again, if I see trends, ideas, or interesting topics, I may pick them up in future articles for Substack or for videos. And you can check out all my contacts in the links that are in the comments or description of these videos. Talk to you soon.